This is the opening argument opposing the proposition. In order to evaluate whether or not international law is effective, it's necessary to consider what the purpose of such law is. Harris identifies four purposes of law, based on which I address the following question. Does public international law achieve the purposes of a system of law to 1. Establish standards, 2. Maintain order, 3. Provide a mechanism for dispute resolution, and 4. To protect the liberties and rights of the parties to whom the law applies. So in regards to point 1, establishing standards, international law has two major shortcomings. First, there's a lack of agreement on content and meaning. Curry points out that states will intentionally commit wrongful acts, but legitimate their actions based upon rules of international law which they characterize as definitive and binding. Morgenthau also points out that states will interpret and apply international law provisions to suit their particular conceptions of based on their own national interest. This means that international law is not very useful if it's so vague that it can be twisted by any state to justify its own purposes. Second, international organizations such as the G7 or the UN General Assembly rely on consensus decision-making, resulting in standards that equate to the lowest common denominator. Lay points out that the international system lacks mechanisms to allow true debate and integrate different proposals and opposing arguments, and to allow a realistic possibility to revise standards or laws in the future. This means that those lowest common denominator standards don't constitute a legitimate representation of the true needs of international actors. In regards to maintaining order, there's a systemic inability to establish mechanisms for the enforcement of law, and the question of who should be doing that arises. It is possible to argue that this falls on the UN Security Council, but in reality that enforcement ability is crippled by the effective veto power of each of the 5 permanent members. The closest thing to an obligation for enforcement might be something like in NATO with the invocation of Article 5, but that's limited to its members and to outstanding circumstances. And the concept of universal jurisdiction is of little help because it relies on the will or interest of states, who are the ones who make the laws for their judiciaries. Even in what should be clear-cut cases of intervention, such as the Rwandan genocide, General Romeo Dallaire of the UN mission had to directly disobey UN orders in order to protect victims. So relying on the will or political interest of states is problematic if they are not even willing to intervene in obvious cases of basic human rights infractions. 2.3, a mechanism for dispute resolution. Morgenthau says that the International Court of Justice has filled this gap. However, even the ICJ has important shortcomings. It can only make a ruling where a bilateral or multilateral agreement is already in place, or where both states have made a declaration to accept the ICJ's compulsory jurisdiction. Only a third of the world states have made such a declaration, with the notable absence of 4 of the 5 UN Security Council members. As these represent some of the most powerful states, other states have no recourse if a problem arises with them. For instance, Article 2, subsection 4 of the UN Charter contains a basic prohibition against the use of force in international relations, and the US abused the exception of the principle of self-defense contained in Article 51 by using preemptive force in its highly contentious 2003 invasion of Iraq. In that case, Iraq had no further recourse other than a war with a powerful member of the UN Security Council. Finally, in relation to protection of the rights of those involved, it falls short because it is based on Western history and values and doesn't account for other cultural perspectives. Chouinette points out that this liberal imperialism embedded in international law means that the system conceals the hegemonic goals of the powerful. And while Chouinette emphasizes that this inequality may sometimes work to the advantage of the weaker party, that's poor consolation for the majority of times when it doesn't work. So because the international system is set up to cater to the goals of the powerful, it can't consistently apply international law in a way that ensures the protection of the rights of states against those who are more powerful. So in conclusion, while public international law may be able to achieve some of the purposes, it will only be in areas where there's already common or complementary interests and there's self-enforcing mechanisms. This means that in cases where there are real differences or the potential for truly destructive conflict, where those international laws are really needed, the system falls short of being able to establish standards that are enforceable, allow for resolution of disputes, and protect the rights of those involved.